Good evening, Captain Retired Matt Edwards with the next installment of Observation Post Weekly Report for 7th of September 2023. Went to the dentist yesterday and I had another filling, and the dentist gave me some antibiotics to help with that hole between my mouth and my sinuses, so hopefully, that'll cure up. Last week, that was why I cut it really short. So, I'll do the actual Dodge coming downstairs there behind me. I'll do 4 items on the list I have, the numbered list. Then I might read off the column I call them. I consider myself an amateur writer. I try to make things a bit more entertaining than just telling people facts. So I wrote a column yesterday about the purpose of the Pension Act, according to the War Implications of Canada case in 1997. So, number 326 in my numbered list, long-term disability taxes. Hansard in 1997. You know the garbage that? Said 75% of disabled Canadians pay no taxes. Now, I put in brackets there around that Altman, Ontario Court of Appeal, 2011 case. Now, the law says in the Income Tax Act 2 conditions that makes long-term disability considered to be deemed to be income, because it's not really income, or they wouldn't have to deem it as income. The first condition is that the payment has to be periodic. So if the payment of long-term disability insurance proceeds is paid periodically, then they have to look at the second condition that the government established in 1971, and that is the employer has to pay a portion of the premium. Now, I believe it's implied in that the payment must be made to a third party. Now, the Service Income Support Insurance Plan, the Sun Life Policy, the Public Service Management Insurance Plan, and the Great West Life Policy for the RCMP, these are all self-administered, administrative services only policies, and the payment is not made to those 4 companies. So therefore, I'm pretty sure that the government can't tax it. That's one very good argument. Now, another important point is that Canada has a tax policy of not taxing the same money twice. Now, the provinces, in a bid to increase their tax revenue, decided to tax premiums for long-term disability insurance. Now, therefore, if you think about it, if a person becomes disabled and they were paying into a long-term disability policy, like from an employer, they paid taxes on the premiums, and therefore, if they become disabled, they cannot be taxed legally on the insurance premiums. That's 2 very good arguments why they can't tax long-term disability insurance premiums, besides which, allowances and other stuff that deems them to be part of employment income. So if they were really income, they wouldn't have to deem it as income. As an example of that, the Canadian Human Rights Act and the Employment Equity Act, they deem Canadian Forces members and RCMP members as employees. Well, if they were really employees, they wouldn't have to deem them as employees. That's the purpose of a deeming law. Number 327. Canada Revenue Agency, my old employer, they want me to file taxes. But I don't trust the government. Doesn't matter that in my case, as my CRA T4As were filed with CRA might be enough. So, the fact that I haven't filed my taxes, and maybe I'll say this and then keep going. In other words, there are tax filings on account, just no T1 tax return to go with them. When and why did I contact CRA's superintendent? Because I've been blabbing all over the universe about this bullshit. And a person who is trying to avoid taxes wouldn't speak openly about the taxes they're trying to fucking avoid. I'm trying to get them to fix things. So, for example, back in 2014 or 15 or something, I said, hey guys, delete those Manulife T4As from my file because I don't want to be implicated in anything dishonest. I think I'm right. I mean, why are they filing T4A tax information forms with a false insurance provider on it? Because as the Manouche Federal Court 2012 case showed, and the adjoining case, the linked case, was the Butte Estate Federal Court 2012 case, was about the RCMP gross life insurance. So both of those insurances had the government get sued under Her Majesty the Queen. Now, HMTQ. Now we got to use HMTK, His Majesty the King. But, and on that point, this is the way my brain works. Lately, what I do is I send off pictures when I have some downtime, and I'm looking through my old pictures, my photos on Google Photos. And one of the photos I sent to myself on Instant Messenger today was a picture I had of the Group Surgical Medical Insurance Plan, which became the Public Service Healthcare Plan. And they admitted openly that this was an administrative service only policy. Now, normally the government ignores the fact that it's an administrative service only policy, and they vehemently denied that it was when McInnes Cooper, who was Dennis Manouche's lawyers in the 2007 case, because that's when it started, it never finished till 2012, but when it started, they said this plan is an administrative service only policy, and the government said, no, it's not. Oh, no. And they tried to use the argument that administrative service only policy doesn't have any reserves put away to pay for the insurance. That's bullshit. In other words, they're trying to say they just take the business's cash. But see, the CPPD policy is set up with money in the bank, the pool of insurance premiums, and they think that makes the difference. I beg to differ, because what does that matter? The RATCH, R-A-T-Y-C-H, Supreme Court of Canada case in 1990 talked about, they said that group insurance is the same as private insurance. They operate on the same principles. So it seems to me that, from my research, that the government would like us to believe that group insurance is different than privately bought insurance. It's not. They operate, or they're supposed to operate, on the same principles. Number 328, Canada Pension Plan Disability and Tax. And the 2003 study recommended, and the study was by members of Parliament, they recommended that there will be no taxes on Canada Pension Plan Disability. Why wasn't it implemented? If the government, who makes laws, decides that something won't be taxed, then why is it still being taxed? Well, we all know the answer. They don't want to give up. They're addicted to the tax revenue. It reduces their expenses. And it's kind of related to the next point. Number 329. How many current members of Parliament were present for the end bridging vote? Now, Peter Stopper, I recently did a compilation. I went through the history of it. Peter Stopper introduced a whole bunch of private members' bills. I don't remember, I'd have to look it up, but it was a long time. He'd been doing it, and he's not a member of Parliament anymore. He didn't win in 2015. But during his tenure, he tried to end the long-term disability, the Canada Pension Plan Disability and the Canada Pension Plan Retirement bridging part of all the federal, only the Canadian Forces and the RCMP Superannuation Acts. Now, I shouldn't say this because, it sounds bad, but I called Peter about 6 or 7 years ago, and I said, hey, Peter. Well, he called me back, I think. I said, listen, I saw you were trying to end the bridging, and I thought that, you could try the legal route. You could just say that it's illegal because, Canada Pension Plan Act, Section 65(1), and Financial Administration Act, Section 67, that states that the Canadian Forces Superannuation Act, Section 15, brackets 2, brackets B, is not legal. Like, that, he's kind of sloughed it off. I was thinking about why he might do that, and I don't want to throw him totally under the bus, so I think that as a politician, even though he is a lawyer by trade, he probably wanted to use the political means to get consensus and have everybody agree. Well, Eventually, it got to the point where we had a minority government. When he was doing the bills, and these were private members' bills, and the conservatives had a majority, well, he was pissing in the wind. But at one point, I think it was 2008, at one point, there was enough liberals, Bloc Québécois, NDP, and I don't know who else there might have been, the Green Party maybe or something. Well, they had more votes than the sitting Conservative Party because they had a minority government. So there was a couple of things that you should take note of. They voted to end the Pension Act clawback under the CPPD policy. Now, I'm not bragging, but I mean, I have my doubts whether you can have a vote in Parliament and what appears to be a contractual clawback. Because, you know, I mean, the government shouldn't interfere with contracts. Maybe I shouldn't mention that, but the case is over, so, well. And the other thing they said was they wanted to end bridging. Now, I've talked about bridging a lot. I spoke to the person who was mentioned in the Hansard, the record of parliamentary debate by Peter Stauffer, John LaBelle, before he died. And they never should have. I don't know when someone started to do this fucking bridging. There's no such thing. It pisses off all of the groups in the Federal Public Service, Canadian Forces members and the RCMP members and everybody because they don't get their full pension. It pisses off the public because the public thinks that we're getting special treatment. And to make it worse, is in 1964 on the 9th of November, because I have a copy of it. I'd love to find a video or an audio recording. But a Mr. Chatterton of the Conservative Party, probably called the Progressive Conservatives back then, asked the Minister of Health and Welfare, Julie Marsh. He said, listen, what will happen if a public servant becomes disabled, gets his public servant disability pension? Will he also get the Canada Pension Plan disability? Now, you wouldn't ask the question unless you wanted a certain answer, and he was in the opposition. I think he wanted her to say, no, they wouldn't get both. That'd be crazy. But she said, no. Of course, he'll get both of them, and if he has 5 or 6 different pensions, he'll get them all. Now, I think she was a lawyer, too, and she probably knew pensions are property. Now, if you have 5 or 6 different pensions, and they all have a disability pension built into the structure of the pension, and you become disabled, then you have to get them all because they're your goddamn property, your assets, your savings. Now, someone changed the whole name of the game, and they put into the law Section 15.2b of the Canadian Forces Superannuation Act, Section 11.2 or 10.2 of the Public Service Superannuation Act, and Section 15.2b of the RCMP Superannuation Act. And they put in there that unless you prove that you're not getting the Canada Pension Plan disability and you want your pension, we're going to deduct the bridging amount. So they made it a negative law, sort of like negative billing on a cable company who wants to add extra channels. And they say, we're adding these, we're charging you, but if you tell us you don't want them, then we won't charge you. Well, here the government made a law that said you have to prove that you're innocent. You have to prove that you're not disabled, you're not getting a Canada Pension Plan disability pension, and then we'll pay you your full pension. That's unlawful. They're withholding your property. I think I'm waxing on more about this than I thought I would, but I think it's based on the fact that people think that the public, the taxpayer, has an interest, a legal interest, in our pensions. It's totally ridiculous. The government, as an employer, has to pay people to serve it. Now, part of the pay is paid to them at the time to pay for their expenses, their living, and some of that pay is put away for the future, deferred remuneration. And when you retire, whether it's healthy or disabled, you get your money back that you saved. Okay, that's all it is saved money. They bank the money for you, which makes them a fiduciary. They might vehemently deny it, but anybody who holds somebody else's property on for them onto, they have possession of it, and they promise to give that to them at a later date when they retire. You are a fiduciary. Now, just in case people, if anybody's watching, just in case anybody don't know what a fiduciary is, well, a parent-child is a fiduciary because the parent has the power over the child, and if they don't do things right, the child could die. So the power of life and death. A priest, parishioner, telling sins and stuff, and they've got to keep them secret. Even, they're not allowed to tell them. A lawyer and a client. Even if they're getting paid by the client, which could be looked at as contractual, there's a difference in knowledge. A doctor and a patient is another example of a fiduciary relationship. So because the government is holding on to the money, they have to look after the money for the benefit of the person that they're holding on to the money for. You can't look at this and say, we're going to pass a bridging law which benefits us, because that will be a breaching fiduciary principles. You just did something for your benefit and not the benefit of the pensioner, whose money it is. Now, I could probably go on all day about this, but I'll get out that column I wrote, because even if I'm not swallowing gunk like last week that made me feel sick and stinks from the infection I had, I still don't want to be here all day doing this stuff. And I'm starting to do up a statement of claim, and I'm thinking about trying to get some lawyers, maybe if I can find someone to tweak it a bit and try to figure out what would best get the interest of lawyers to try to look at it this as either setting a precedent if I do a singular case or doing a class action. Anyway, and the funny thing is after I did the column, and sometimes I get a bit wishy-washy or uncertain, so I don't put it out right away. But this time I whipped it up. It usually takes me about 10 or 15 minutes. This one took me about a half hour. So after I did it up, I posted it and I put a few pictures to make it look a bit pretty. And I usually do, just as a explanation of what I do, is I usually add 3 pictures of people in the military or ships or planes or tanks or something, and I usually put 3 things about proving my point, that I'm not just telling you my opinion. Whatever I wrote about, I try to find a case or a statute or something that proves what I say is not bullshit. Okay. So, the irony is I looked up something after, and instead of it being sustenance like I put in here, and I looked up the word on Google and found it in a dictionary, it might have been subsistence. But they mean roughly the same thing, so I'm not going to change anything. I'll just explain that, on my full disclosure type, that I don't know which one they actually use, but it probably doesn't make much difference. Debt, gratitude, and sustenance. An observation post column by Captain Retired Matthew Edwards, CD, BPE, BED. The pension arising from the Pension Act 1919 was stated by the courts in 1997 to be paid for 3 things: debt, gratitude, and sustenance. The dictionary definitions of these 3 simple words are Oxford's Learning Dictionary. Debt, a sum of money that somebody owes. Oxford Learning's Dictionary, gratitude, the feeling of being grateful and wanting to express your thanks. Now, I kind of think that's a circular definition because it used the word grateful in the definition of gratitude. That's just my 2 cents. Oxford Learning Dictionaries for sustenance, the food and drink that people, animals, and plants need to live and stay healthy. So I stand by my word. It's the same thing as subsistence. Sometimes these words are joined together in such phrases as debt of gratitude. The Cambridge Dictionary, to have a reason to feel thankful or grateful to another person for something good that they have done. I think that soldiers putting their life on the line for the country is definitely something that's been in the Hansard as a debt of gratitude, and I agree. Example, there are no words that can express the debt of gratitude that future generations will owe them for their sacrifice. Now, that's from the dictionary. That's not my example. Now is my own writing here. The pension is said to be a debt repaid. Obviously, it's the same or very similar to the debt owed to a victim of tort. When someone owes the person harmed by their actions. Not an exact analogy, as the harm might have been inflicted on the military member by the enemy of Canada. However, the nation did place the military member in harm's way. Any injury or debt would be a national or crown debt for the person to having suffered a personal injury. Gratitude, playing a part in the pension, is debatable. Gratitude in what direction? From the disabled veteran to the nation it served, from the Crown to the former military member. Obviously it's the latter, but it's not exactly clear because of that last item, sustenance. Sustenance is a word related to charity or welfare. The state will provide enough money to ensure sustenance or survival, but no more. The word has zero application in the case of a disabled and service veteran. The legal and moral debt payment will provide the veteran with the ability to provide for his own sustenance if the rate of the pension is set high enough or administered properly. Now, the reason, editorial comment, why I put administered properly in there is that there are times that the government doesn't admit that someone was hurt in service to save money, and that wouldn't repay the debt owed to the person injured in service. However, an example of this being mishandled is the failure to follow the military long-term disability insurance, or LTD, to be paid in addition to the pension. Prior to 1976, there was a prohibition on getting the Service Income Support Insurance Plan, or CISIP, Policy 901-102, and a pension at the same time. Yet, veterans were only getting, on average, 20 to 30% awards under the Pension Act, which is, prima facie, not enough money to live on. Using the 1985 rates for the pension, this would amount to about $388.13. That was in 1976. Now, it would be $969.41 in 2023, or $190 in 1976, my mistake. Canada has statistical studies to show how much is needed for sustenance, known as the Low Income Cutoff, or LICO, which was $3,276 for a single person in 1976. However, most Canadian Forces members and veterans are married, about 72%. Assuming 2 children and a spouse, the LICO goes up to $6,194. That's in 1976 dollars, remember? So it is clearly seen that the pension did not allow for sustenance. This is why the Crown decided, I'm inferring this, but I think it's true, decided to allow the payment of CISIP and the pension at the same time starting in 1976. If that had happened, it would be good public policy that they did as they announced, because they announced it. However, they decided to add a clawback of the pension in the policy. In other words, the alleged insurance contract negated the public policy announced where a disabled and service veteran would get both to aid sustenance. In fact, a 2005 Veterans Affairs Canada reference paper, that's where I get a lot of my information about some of these policies, stated that the clawback of the pension caused a moral problem relating to this gratitude, presumably. A veteran not injured in service would receive more CISIP long-term disability insurance than a veteran hurt in service facing a pension clawback. Now, I think I'll explain that just in case you're not. Someone that's not hurt in service will get 75% of their salary and have no clawback. So a person hurt in service would have their reduced service income support insurance plan because Manulife, acting on behalf of the government, took the pension into account until Manus won his case. So that sends a very bad message to society that a person who's injured in service gets more money in insurance than a person who was injured in service. I hope I said it right. The person who's injured in service should get at least the same or more. Okay? I think anybody who watches me would agree. Listen, before I go on, even though I'm almost finished, I'll explain that in more legal terms. In order to get the pension, you had to give up the right to sue the government in a lawsuit in tort, like workers' compensation. So the veteran actually paid something that wasn't cash, the right to sue in tort, to get the pension. So they gave up something that was valuable. So why should they just break even? Anyway, surely this is the wrong approach. How would that help with public policies of recruitment and retention of military members if a person received more for a non-service injury than a service injury? To sum up, the question we have for the new generation of the disabled and service veterans is, does Canada still have a public policy of paying an injured and service veteran in relation to the Crown, the debt the Crown owes? Gratitude and sustenance are trivial arguments. Is the Crown liable to repay the disabled veteran enough to make them whole? Now, even though I stopped the column there, let me explain what making whole means. That's what a lawsuit in tort is supposed to do. Someone harms you, were healthy, you were whole before you got harmed. So if someone hurts you, they have a legal liability to repay you for the damage they caused. And that is determined by a judge. Now, employers, including the government, found this could have put them out of business, caused a lot of problems, so they invented this thing called a Great Compromise, I think in the early 1900s. I can give that and not be wrong, but I think it was the 20s. So, as I said earlier, the Pension Act was seen to be akin to, the same as, almost the same as, workers' compensation. And workers' compensation was where the government introduced laws that imposed the rules on the employers and the employees. And they said, you give up the right to sue and you will pay for all of the workers' compensation system. Now, the rules became the Meredith principles, after a judge named Meredith. And I don't remember them all offhand, but one of them was the employer has to pay all of the premiums, all of the costs. The worker, the injured worker, and the healthy workers do not have to pay 1 cent of the cost. Editorial note there, it only appears that the worker doesn't pay the cost, but for now, well, that's one of the Meredith rules. Because if they, for example, workers' compensation boards across the country now take Canada Pension Plan into account. Sometimes they take it all into account, and sometimes they take half. Now, you are subsidizing the employer who has to pay all of the premiums. If you take something like a private pension from a company or the Canada Pension Plan Disability into account, you reduce the premiums or the costs of the workers' compensation system for the employer. So you are breaking the Meredith rule, the Meredith principles. Now, this is not just my opinion. I'm quoting a case called J.D. Irving, New Brunswick Court of Appeal, 2012. And they said that categorically because the Canada Pension Plan retirement, not the disability part, was being taken into account and reducing the workers' compensation system. And in fact, that's even worse because you're talking about not the Canada Pension Plan disability being taken into account, but people who were healthy, retired and got the Canada Pension Plan retirement, and Canada Pension Plan will be taken into account by the goddamn workers' compensation system to save money for the employers. Now, that was ruled to be illegal, and they had to pay $90 million back to the injured workers because they were illegally taken into account the Canada Pension Plan retirement. Now, I think the government and the courts are in on this because they put in there a note that didn't matter because it wasn't about Canada Pension Plan Disability, but they said we got no problem with them taking Canada Pension Plan Disability into account. Now, if I was going to court about this, which I think eventually I might, although workers' comp I probably won't be able to because I don't get it, I will point out that the judge made what was called an obiter. He was speaking in obiter, I think it's called. He was making an offhand comment that doesn't relate directly to the case because Canada Pension Plan Disability wasn't at issue in the trial. Now, if the comment was considered to be what's called the ratio decidendi, and I hope I'm getting the Latin phrase right, it's the reason for the decision, and therefore it has to be taken into account, the comment about the Canada Pension Plan Disability, that there will be no problem with it. Now, See, I can't help it. I've been discussing this so many years and trying to get people to wake up and smell the coffee. There's a law that Canada has called the Statutory Instruments Act. And as part of the Statutory Instruments Act, judges across Canada are required or deemed to have knowledge of statutory laws. Now, the Canada Pension Plan, Section 65(1), says that no one can touch the Canada Pension Plan. Now, they can't say we didn't know about it because of the Statutory Instruments Act, but they're turning a blind eye generally to the fact that the Canada Pension Plan is being used to subsidize long-term disability insurance, pension plans, and workers' compensation. They haven't been allowed to take it into account for tort lawsuits because Canada Pension Plan disability is considered to be the same thing as insurance. So that was decided in the Sustenance Supreme Court of Canada case in 2002. And they said it has nothing to do with work, even though you pay contributions to it when you're at work. But you can get it up to 2 years after you finish working. So it has nothing to do with work. And in fact, it's paid on the same basis as an insurance claim. So you buy insurance and you insure against a risk. In long-term disability insurance and Canada Pension Plan disability, the risk is disability. Not just disability, but enough of a disability that you are unable to work. So the way they said it is that once the risk happens, you have to get paid. Now, isn't that interesting? Because the government doesn't want to pay Canada Pension Plan disability to disabled people. It wants to have a definition that it reads in the way it wants it to. So it wants people to contribute to the plan to subsidize other people, but it wants to not pay the Canada Pension Plan disability. Now, in the meantime, the government should know about the Sustenance case. In fact, because the case was against the government, the federal government. A prisoner, a federal prisoner, fell off a roof. Because he fell off the roof, and somehow the government was negligent. I didn't read into all of it, but I know the government was found guilty of negligence and had to pay him damages. Now, because they had to pay him damages, the Department of Justice lawyers tried to use Crown Liabilities and Proceedings Act Section 9, which prohibits a lawsuit when you have gotten a pension. So they examined the idea of the Canada Pension Plan disability payment. Is it a pension that is barred from lawsuit according to the Crown Liabilities and Proceedings Act, Section 9? And the judges were pretty harsh with the Department of Justice, because the purpose of the Crown Liabilities and Proceedings Act is to allow lawsuits. Before that law came into effect in 1953, they said the government, the Crown, could not be sued. The government could do something wrong, but you were shit out of luck because they had Crown immunity. So the government never thought that was fair. It isn't. Why should the government, just because it's the Crown, get away with something when it does something wrong? So they brought in a law that said you can sue the government when we do something wrong. But they didn't want to overcompensate people. So they said if you're getting a pension like the Pension Act pension, or the Aeronautical Injury Something Act, or this act, or some other act that are meant to replace the lawsuit in tort, you also cannot sue the government and get damages in tort. Seems perfectly logical to me until, I wish I didn't have this brain to think things up. Who says the government should get the savings? If somebody has to be deducted from somebody, well, if you're getting the Pension Act pension, shouldn't the lawsuit in tort be allowed to take the Pension Act pension into account and convert it into a lump sum, because tort lawsuits are paid in a lump sum? So an example of this was the Salts British Columbia Court of Appeal case in 2006. And the judge ruled that the Pension Act pension will be converted into a lump sum and deducted from the damages. Now, I think that is a despicable ruling by a provincial court judge, because it ignores Pension Act Section 30. Pension Act Section 30 says that nobody can touch an award of a pension under the Pension Act? Nobody. And the reason for this is that it's a personal injury damages replacement. Okay? You can't let somebody take that into account. So what I'm saying is that if you're allowed to take something into account in those cases, because the principle of overcompensation, the compensation principle is what relies, the tort lawsuits rely on the principle of compensation, that you are allowed to get damages up to and including the exact amount that you suffered in damages, but you're not allowed to get 1 red cent more. So based on that, they brought into the Pension Act, Section 25, and they said that if you get a workers' compensation or a lawsuit in tort, you get some money like that for the same thing that caused you injury in the military, then we will convert that lump sum into a monthly payment and deduct it from your pension. So the federal government wrote a law that said they will get access to the tort lawsuit. Now, in very specific circumstances, recall. But the provincial court judges ignored the Statutory Instruments Act, once again. They ignored Pension Act Section 30, they ignored Financial Administration Act Section 67, and they ripped that lady off of her. She was awarded $930,000 or $970,000 in damages for becoming injured as an RCMP member. Even that ought to have been, or could have been, barred by Crown Liability and Proceedings Act Section 9, because normally if you're getting a pension, they would have said, listen, you can't sue. It was a very novel and interesting argument that they said, well, the province of BC hired the RCMP, so we're not suing the RCMP, we're suing the province of BC. Some might disagree with that. That was allowed to proceed. I presume they looked at the Crown Liabilities and Proceedings Act, Section 9, and said, that sounds like a good enough argument, we'll proceed with the case. Now, just as a matter of fact, and before I go, I will mention that thing because it comes up often. The Crown Liabilities and Proceedings Act, Section 9, was tried to be used by the Department of Justice in the Dennis Manouche class action. Of course it was thrown out. CPPD, they tried to say that because the Pension Act is being paid, I'm trying to remember the exact thing because it was just such an absurd argument in the first place. Because CPPD isn't the same thing as an award in tort, you see. So the things that are prohibited from getting a lawsuit in tort is when you get something that's akin to a lawsuit in tort. And I can give you three examples. You can get the Pension Act, you can get the new Veterans Charter stuff, or possibly the Government Employee Compensation Act, or workers' compensation itself. Now those things are meant to be a lawsuit replacement. Okay, so instead of having an outcome which is up in the air, okay? The idea behind the Great Compromise is that you could go to court and the employer always had more money than the employee. So you might end up representing yourself or having a bad lawyer. So the great trade-off was actually pretty positive in my mind because it guaranteed a worker injured on the job that they would at least get something. They might not get all of the damages that they're owed. A report that I read by Peter or Paul Weiler, I can't remember his first name, it begins with a P. In 1987, he did a report up for the Ontario Workers' Compensation System when they were going to change it, and he called workers' compensation a system of rough justice. And the reason he called it that is that the individual person that gets injured on the job may or may not get good compensation. They might get more, or they might get less than what they should have gotten individually, but the system as a whole, it is fair. Now you can buy into that argument or you can not buy into that argument, but I like the idea of having specifically, you know, in the common law, for example, there's a rule that says that you have to take your victim as you find him. So if you're driving down the road and you get distracted and you don't see the person walking in front of you and you ram into him, if that person is a vagrant, a bum, unemployed, no prospects, you won't have very much damages because you have to take the victim as you find him. But if you drive into a doctor or a lawyer or somebody else that has a lot of economic potential, then I hope you got lots of insurance because you have to take the victim as you find him. Now I was going to shut up, but I can't help it. That turned another domino over in my head, and that's one of the most important criticisms that I would have of the Pension Act pension. Canada's system is almost communist. It used to be anyway. Now it's more free, more capitalist. Because now it's based on your salary when you're in the military. But before 2006, under the Pension Act, they determined how much you're going to get based on the table of disabilities, which is a outdated, archaic, bullshit piece of legislation that they still use for the disability award, which is now called the pain and suffering compensation. The meat chart. So if you had somebody at Veterans Affairs assess you at 90%, you get 90% of whatever rate was set for the Pension Act pension. But if you were assessed at 100%, you would get X number of dollars. Now, if someone was a captain, a general, or whatever, or a private, they'd all get the same rate if they're assessed at 100%, which is, I think, communist. Okay? Might sound bad, but everybody isn't treated, everybody isn't born equal. Okay? You might have equal opportunities, but it shouldn't be this society where everything is the same and I don't care if you were this or that. I mean, it should be what the common law says. And the common law says you have to take the victim as you find him. So if you're going to set up a system, it should take the victim as you find him. But I know that the government wouldn't be able to pay all of the amounts owed, but it should be closer to reality instead of some arbitrary figure. Because Canada set up a system that would pay a basic rate of a pension, and then it set up a supplementary pension called the spousal pension and a supplementary pension for the children. And then in 1970, they added an exceptional allowance, incapacity allowance, the EIA, and that was for anybody disabled according to the table of disabilities at 98 to 99 or 100%, and they considered them to be totally unemployable in the general labor market, so they paid them an additional allowance this time, because the other ones are pensions. For some reason, the government has a different attitude or legal means, they treat pensions different than allowances. Okay? In the military, they have lots of allowances. Okay? Like you have submariners allowances, divers allowances, you have paratroopers allowances. I had a thing called casual land duties allowance. If you're out in the field overnight, more than 24 hours, then you get a casual land duties allowance added to your pay for the hardship that you have to suffer. Now, on that note, and I wish I could shut up sometimes, there was a guy that did a lawsuit a few years ago, and he successfully added the danger pay or something. I don't know exactly which allowance he got, but he had it added to his salary for the purposes of determining what long-term disability insurance you'll get under the Service Income Support Insurance Plan. Now, I called him because I can't help it. I'm kind of a busybody, I guess you could call me. I said, listen, I hope you don't mind this criticism, but this will help. Your case will help people who are disabled in service. Why not? Well, I'm assuming that they're going to be getting the income replacement benefit from Veterans Affairs, and if they get more assistance because you won your case, then there'll be more money to the government to claw back under Veterans Affairs. So in effect, your lawsuit meant nothing to people who were injured in service. Now, I'm sure I didn't like that. I don't recall what his response was, but that's a valid criticism. It also applied to the Pension Act pension clawback for CPPD. Okay? I've had veterans, Captain Retired Denis Ouellette, Corporal or Master Corporal Karina Kelly, and they both got huge whopping bills for a crown debt that the government said they owed because they got the Canada pension, or they got the Service Income Support Insurance Plan, at the same time that they get the income replacement benefit, and therefore they said they were overpaid. Now, this is exactly what I was saying, that, you know, like, what was the point of winning the case? Denis was part of the Manouche case. So they shouldn't have been allowed to touch the damages that he had, because the first thing that you ought to think about is that the person that injured them was the government. The class had to sue the government to get more money under the SISP, long-term disability, so they were the wrongdoer. Now, the government was also Veterans Affairs Canada. So why should the government get to save money on Veterans Affairs side of the house? Because the government who wronged the person had to pay damages to make the person whole. It's fucking absurd. But I think I can explain what they're doing. They'll just say, we just work here, we have to follow the law says that we have to take into account this. But, I hope I'm not being too theatrical tonight, throwing a few gestures in. The Service Income Support Insurance Plan is not listed as a clawback under the law. Now, get that through your head. The government is clawing back the Service Income Support Insurance Plan, but they didn't write a fucking law to authorize it. When is that going to bite them on the butt? I can't do it. I don't get the income replacement benefit. Well, I could do it if a lawyer accepted my points and went to the court and we argued that this is a public interest case. But those don't get accepted by the courts very often. Okay, like, I know about it, but it doesn't happen to me. Usually to take some of the court, you have to have a legal stake in the game. So, I would love to do it. I'd like to see my democratic government obeying the rules. Okay? You harm someone, you don't benefit from it. That's the rules. Everybody knows the old saying that, what's it called? The dishonest, you shouldn't benefit from a crime. Crime shouldn't benefit. Now, it wasn't a crime under the criminal code, but it was still a civil wrongdoing in contract law. So the Service Income Support Insurance Plan should have been paid without taxes, because it wasn't income, it was damages. It was meant to make the person whole. Now, if you get money to make you whole and somebody claws it back, you are no longer whole. How come they can't get that through their fucking thick skulls? Maybe they'd think differently if it was happening to them. Now, this is the thing, and I got shut up. This is the thing I don't understand. When I've called pension people and I explained about bridging, it will happen to them, and they still defend the government. I don't get it. If I ever get to the point where somebody listens or I bring it to court, I'll say something like, here's my evidence from the 1964, or November 9, 1964 Hansard, and the intent of Parliament was that a disabled person will get both the Pension Act, or the Canada Pension Plan Disability, and their retirement pension. Then I'd say, it's your turn now. Show me the evidence that shows you have the right to bridge my pension. They won't be able to do it. I suspect Parliament never debated bridging. Show me the evidence where they talked about it and they decided that they would take away our property and civil rights, which do not belong to the federal government. Section 9213 of the Constitution Act states that that is an exclusive jurisdiction of the provinces. So if the provinces own this exclusive right to deal with these matters, then how can you put a statutory federal law into place that affects my property and civil rights, you son of a bitch? And I tried not to use a much more offensive word where one man gives fellatio to another. Okay, so I still said it, but I said it in not so many words as somebody's sucker. Because they should act honestly. The government we elect They shouldn't accept lies, and they shouldn't be willfully blind. They shouldn't turn a blind eye to all this shit. John LaBelle and them were right, they just didn't have the right arguments. Peter Stopper was right, but they didn't take it to court. Nobody else has taken it to court, so I might end up having to do it, but one of the reasons I do these broadcasts is hoping somebody else will see my point and take it to court. I would help them out as much as I can, but a lot of times I don't have a stake in the game. On account of the pension plan disability and some of the other stuff, I got lots of stake in the game. Now I'm getting to the point where I'm half afraid that I could die before all this stuff gets fixed. And that's my biggest fear. I don't have too many fears, because nobody take on the government like I have if they were a coward. Okay, sometimes I've had to take a break from it and not look at it for a while because I can't believe this shit's happening. But ever since, and I bit my tongue that time, excuse the slur, ever since I've discovered the shit, I've always tried to do the right thing. I reported things to the right authorities. I contacted the Competition Bureau, and I said, look, all of these insurance plans they haven't been tendered. Look at the Senate Committee on National Defense and Veterans Affairs evidence on 2008, 2012. That's your evidence. They said they weren't tendered for the Service Income Support Insurance Plan. Therefore, we're pretty sure the other ones haven't been tendered. Therefore, they haven't been tendered. There's been no competition. So therefore, these people have committed a civil offense. Please investigate. Now, I think I told them I didn't care if they got back to me. But, they should have a duty to look into that, because that was a well-founded complaint. Okay? If this was really Sun Life, Manulife, Industrial Alliance, and Great West Life, if this was really those insurance companies that were doing these policies and they weren't tendered, that would be a pretty serious offense. The government contracts regulations under the Financial Administration Act requires any contract over $25,000 to be publicly tendered. Now, so when the Auditor General said in 2012 that the Service Income Support Insurance Plan has been in effect with Manulife or Maritime Life and Manulife since 1969, and it hasn't been tendered, the public might have to spend more money because it hasn't been publicly tendered. Well, they never brought up the fact that the law was being broke. And that pissed me off. Because, it's not automatic. There are 4 exceptions to the rule about government contracts always being tendered. One of them was the $25,000. So if the contract was $24,999, it doesn't have to be legally tendered. Another one is a sole source contract. Like, if you wanted the General Dynamics F-16 Fighting Falcon or Viper or whatever you want to call it, that's the only manufacturer. You can't have a tender if you want that jet. So you can have an exception to the requirement for tendering under the sole source contract rule. There's 2 more, but I don't care about them right now. My point is, why didn't the Auditor General look beyond the fact that the taxpayer might have to pay more? Because I can't help it. I'm not trying to brag about my intelligence, but the Auditor General was wrong. The Service Income Support Insurance Plan doesn't affect the taxpayer because it was set up in 1969 under the Section 39(1) of the National Defense Act, which sets it up as non-public property. So it's not the government's property. It's our property. Now, I'm starting to feel a sneeze and that stuff was starting again, so I'll shut up. But my point about that is, when I've been looking it up, they actually have a much higher figure under their own regulations or constitution or something, or whatever it is. Can't quote it off where it is. But I think it's $250,000 they use instead of $25,000. So according to the non-public property rules, the contract has to be less than $249,999. But if the CISA policy, which is much more than that, obviously, is violating either the government contract regulations or whatever regulations or constitution of the non-public property entity called the Canadian Forces CIFCEL. Anyway, then it could be a civil wrong. But the fact is, the government don't want to tender it because the government don't want anybody putting their eyes on all of these documents. For example, and I wish I could shut up, the Parliamentary Budget Office wanted documents from CISIP. But they sent a letter to them, and I've got a copy of it because it's under the access to information stuff. I didn't do it, but I found it later. They said this stuff is so sensitive, commercially sensitive, that we're not going to provide you with the information you want. Now, what a crock of shit, because it's the government who's the underwriter, not Manulife. So, when the Parliamentary Budget Office wants more information about the activities of the government's administrator, you can't claim that you have a commercial interest in keeping these secret. You just can't. It's not your secret. It's the people's secret. So you don't tell the Parliamentary Budget Office, excuse me, but you can't have it. If it was really Manulife, they'd be well within their rights to tell the Parliamentary Budget Office to fuck straight off under privity of contract. You have no right to ask me for this information. You aren't party to the contract. But that's not the case. Under the Manoj case, we know that the government is the underwriter. Anyway, listen, getting dried out. That stuff is getting worked out. Thanks for watching, and I'll see you next week.